this complex terrain, we are privileged to have two wise voices from the bar and the bench with us. We are deeply honored to welcome Justice Manmohan, Judge of the Supreme Court of India. Sir embodies the balance between constitutional restraint and contemporary realities, recognizing that while courts do not follow trends, they must endure over time. Joining him today, we have Mr. Guru Krishna Kumar, Senior Advocate, a leading voice of the bar, known for his clarity of thought, intellectual rigor, and the rare ability to explain difficult legal ideas without requiring a constitutional bench or a disclaimer. I have personally seen him dissect the most complex legal issues with precision and ease, and there's so much to learn from his craft. Together, they bring the perspective of the bench and the bar to a conversation, not a debate, not an argument to be won, but a dialogue to analyze and find answers to difficult questions. With that, I invite you to sit back, sip your chai and coffee, and engage with a conversation that promises to be thoughtful, candid, and by legal conference standards, positively lively. On that note, sir, with your permission, I'll start Justice Manmohan. Sir, legal news portals and knowledge platforms often publish extracts of court hearings, pre-judgment commentaries, and immediate analytical interpretations of proceedings and judgments, sometimes even before the full official judgment is released. This can, and more than not, does land to preconceived notions about the judiciary and judges based on selective excerpts. So what institutional safeguards can courts adopt to ensure that public understanding remains anchored in the judgment rather than the momentary excerpts?
First of all, I would like to express my gratitude and my thanks to the SCORA for having invited us to Goa. It's a beautiful setting. We are sitting by the seaside, but having a fireside chat. Having said that, I think the question that you have raised is a very important one. But I think what it requires is an understanding of the ground level reality. And I will place before you 4 facts as I see. And I think we must have a response keeping in view those 4 facts that I'm underlining. One is that there is hunger for court news. See, when I had joined the profession, no one wanted to know what was happening in court. But today, everyone wants to know what is happening in court.
Correct.
And everyone wants to be the first person to know what is happening in court.
Absolutely.
So, therefore, whenever an important judgment is delivered, you will find that the judgment is delivered at 10:30. At 10:35, there is a live wait which starts, even before the judgment has been uploaded. The impression that is embedded in my mind is with regard to one Constitution Bench judgment that was delivered with regard to a religious practice. Since it was a Constitution Bench, there were various opinions. There were more than one opinion. In fact, I think 3 or 4 opinions were rendered. The Chief Justice, because he has the priority, he read his judgment first. He upheld the validity of that custom. So it was flashed all over that the Supreme Court has upheld the validity of that religious custom, while the fact was that the Chief Justice was in a minority. So this is the pressure of the fastest finger first. And because of this, the attitude that you want to know everything first, or even oral observations of a judge are being reported. They're being given wide publicity. Now, if one is hearing a matter, and especially when one has to write a judgment, one would like to have the best reasons to be incorporated in that judgment. And how do you get that? You normally play the devil's advocate by posing a large number of questions to the party. You may be inclined, but you never show your inclination, and you put some difficult questions to get the best answers so that they can be incorporated as reasons. But what happens is that it is portrayed as if the judge had asked question X, the judgment that is delivered is Y, there is a disconnect between two, something has happened. So that is happening because people are not understanding how the system functions. The third thing is, and I think we have to be cognizant of this fact, that we are not going to control the media. That is not the option before us. Media has to be left free. They have to take their own calls. We are not going to control it. The fourth fact is, and I think that is very important, is that in today's world that we live in, public has no patience to read a 500-page judgment or a 300-page judgment. They want to have a 280-character tweet, and they want to understand the judgment from that. That is the ground level reality. These are the facts. So what are the options? The options are, one is to have a SOP or a convention and ask everyone to abide by it. To my mind, it is difficult. What will happen if it is breached? What will happen to the violations? Will you take action at the pain of contempt? And I think that will get the court entangled in a serious issue, which may not be beneficial for any of the stakeholders. The other is that we'll all have to adapt. And adaptation will have to be done by the bar, by the bench. And that's my personal view. One, I think the judgments will have to be much shorter, much more crisper. They'll have to have cogent, convincing reasons in a very short, number of pages rather than there being long judgments. The second is the bar will also have to play an active role. Associations like SCORA would have to play an active role, to my mind. They'll have to fact check the narrative that is being built around a particular judgment. They can always do that. They have trained legal minds at their disposal. If someone is indulging in a narrative, a particular channel or a media house or anyone, or a litigant itself. So they can fact check the narrative, they can point out the relevant passage of the judgment, they can ensure that that judgment, the relevant paragraphs of that judgment are available to the public at large. The other thing is that all the stakeholders will have to invest in public literacy. We have to inform the public at large that, for instance, there is a difference between what the judge orally observes during the hearing and the final judgment that he delivers. See, people must know that judges read their papers inside after the arguments have concluded, and they have the option of changing their minds. It is not that what they have said in court, they are bound only by that. And at times it happens when you go back inside and you read the papers, you reach a totally different conclusion. It happens. Therefore, people will have to be informed about the process, how we adjudicate matters. The other is that, and that's what I've been advocating about, is use of technology. The best way of ensuring that people rely on the judgment and try to find out the basis for the judgment after reading the judgment is that it must be available in the language in which they understand. See, the judgment has to be accessible in the language in which people understand. We are a diverse country. We are a country where various languages are spoken. So if we use technology like SUAS, which is easily available, which is friendly also to use, and if that judgment is available easily, I think that will also help a lot. We have to ensure that the judges, that the judgments remain the anchor for understanding to the public at large, rather than having some meddlesome interloper trying to decipher that judgment and trying to convey it to the public at large. And I think that will be salutary, if these principles are adopted.
So drawing strength from what Justice Manmohan said, Guru sir, that judicial decisions are no longer consumed only by lawyers but by the wider online audience. So from the bus perspective, how do you see that the justice delivery and the public perception has changed over years?
Yeah, see, we have reached a stage where initially the commercialization, if I may say so, of sports took place abroad and in India, where they spoke about how boxing bouts and cricket matches and tennis matches are now available in your drawing room. Then we had a clamor for the legislative proceedings having to be accessed by the public on grounds of transparency and right to know of public, very well taken. Now we have this access to courts and courts being available right in the drawing room for people. So that has made a fundamental difference to what people know of the system and what they want to know of the system, as was pointed out by Justice Manmohan. Now, yesteryears, people really didn't care about what really happened. There's some reporting of a judgment on the print media, and that was about it. And it was largely confined to law reports or those who had to come to courts. But today, everybody wants to have a say, where, if I may say, I dare say, talking of my own brethren, appearance has become performance. I think that's a big issue we have to deal with. And because everybody is watching, what was spoken of as charm schooling for parliamentarians is now becoming to be some kind of an expectation and a requirement of lawyers. To that extent, everybody wants to be seen, everybody wants to be heard. Now, that is where it is a good thing, but is a problem by itself, where the clamor is really becoming like some kind of a commotion. That is where I think, as what was rightly pointed out by Justice Manmohan, there's a need to educate people. Perceptions have to change. They have to understand that it's a process. It's in the process of deciding who's right and who's wrong, and where decisions have to be taken to determine rights and liabilities. There is no question of bringing in sensationalism. I think that's a very important thing as a starting point for consideration of the entire topic.
Justice Manmohan, extrajudicial conduct of judges is something that also shapes up how people at large sees judges and courtrooms delivering justice. So how, according to you, should the judges regulate their conduct outside the courtroom so that the public recognition remains rooted in judicial proceedings and reasonings rather than what is said in media, how the comments are being made, etc. So the conduct of the judges outside the courtroom, sir.
See, courts decide not only controversial issues, but also very crucial issues. And after the judgments are delivered and everyone has exercised their right of appeal, their judgments are normally accepted. And I have wondered many times, how is it that these judgments on crucial issues are accepted by the public at large? After all, a judge has no control over the army, he has no control over the finances, but his word is ultimately accepted by the public at large. That stems from a judge's moral authority. See, when you're sitting in court, you'll realize that most of the work is done by the moral authority that a judge exercises. And it is that authority which is accepted by the public at large. And that moral authority, in no small measure, stems from the fact that a judge is considered an impartial person. He is considered a neutral arbiter, as it were. Therefore, if a judge starts debating in public on certain controversial issues, he will never be perceived by a litigant as a neutral arbiter of disputes. His judgment will never be accepted. Therefore, it is very important for a judge, both on the dais and off the dais, not to get entangled in controversial issues or to give his opinion. After all, if a judge becomes a participant in a debate, he surely cannot judge that matter. I think he will lose that moral authority to decide that matter, as it were. Therefore, the judges will have to resist the temptation of going on the Instagram and counting his followers. See, that is a temptation which a judge really has to avoid. And the legitimacy of a judgment is always rooted in the reasoning given in the judgment. And it will never be personality based, that this judgment was delivered by X judge, therefore I think I'll give it more weightage. The judgment should speak for itself. It should be grounded in the reason. And as you said, the judgments must remain the anchor for the understanding. It's not the personality. Therefore, if the personality is not kept at a high pedestal, but the institution is kept at the highest pedestal, I think, it will ensure that all judges, both on and off the dais, exercise restraint and convey an impression to the public at large that we are impartial, we are neutral arbiters, and we have an open mind to decide the disputes.
No, I just wanted to add to what Justice Manmohan just mentioned. What he really put in very, very simple and nice terms is actually very profound. I think there is a role and basis for the status of a judge and what is decided by a judge. I think the line should be drawn and there should be no attempt at popular legitimacy and public validation in that sense. I think that perhaps is the key, and what Justice Manmohan has said is really that, where there should really be no attempt at seeking legitimacy through a public platform. The judgment has to speak for itself, and all the time we can say over the years and decades, a judgment speaks for itself. I think more should be required.
But Guru sir, most of the times in Supreme Court corridors, we see that if a matter is dismissed, the team of the lawyers would come out, and then the lawyer would tell client, "Judge का mood खराब होगा, इसलिए order अच्छा नहीं आया, और ये तो ऐसे ही order देते हैं, घर से लड़के आए होंगे." And then those opinions of the bar goes on to social media as the client's rant. So how do you think the bar also shapes the comments that goes out on the social media and then, of course, becomes a tweet?
No, I fully agree with you. I cannot dispute the fact that a disgruntled party and their lawyer have a lot to say and have a lot of frustrations. And the lawyer, for his own part, has to justify or say that what has happened is something beyond my control. So there's always this tendency to put the blame on somebody else. There's no doubt about it. It happens. And I must tell you, having said this, there cannot be any denial of the fact that there are judges who are driven by certain considerations. We have heard of judges who are seen as landlord judges. We have heard of judges who are seen as tenant judges, or judges who are in favor of management, or who are in favor of labor. These are all ideological slants, if I may say so. Those realities are there. Now, what happens is, when all of this starts getting shared by the public in an unregulated manner, I think the problem lies there, where what happens is this. It was very beautifully put by a judge. When you have a live streaming or some kind of a discussion after a judgment or a proceeding has occurred, what happens is the bits and parts are taken. Pipin's job.
Hello.
No, one Madras High Court judge put it very beautifully. The judge said, please look at live streaming and telecast of court proceedings as something where you look at the whole, not harvest the fragments. That's really happening. What happens is this. Lawyers, for their part, have their own reasons, have their own issues with what has happened to a particular case. The outcome has affected the client. Therefore, they have their own reasons and justification for what has happened or what has not happened. There is some kind of failure of the expectation. But at the end of the day, now that there is a public glare, not that it's bad, but it comes as a package. Now that it comes as a package, I think it's essential that there is some element of proportionality which is maintained, some element of caution, restraint, which is maintained by all involved, particularly lawyers, because they have a very crucial role to play in the scheme of things.
Mrs. Manmohan, moving from sitting judges to the retired judges, we often see that once a judge has demitted office, they're invited for these interviews, panel discussions, where a lot of legal issues are discussed, including their own judgments. So you feel that ethics of judicial conduct continues to guide retired judges as well, and to what extent?
Yeah, here's the reality. How do you perceive a retired judge? When a retired judge is introduced, it's not said Mr. X, private citizen. It's said Mr. Justice X, former judge of the court. The identification of a judge always remains with the institution even after he has demitted office. He's always associated with the institution. And I think that has to be kept in mind. Because if you are mindful of the fact that the association with the institution continues, then you have to ensure that the dignity of that institution is maintained. Let me say one thing. When a judge demits office, it's not as if he had signed for a priesthood convention. He is not bound by that. He is entitled to share his opinions, and he must share his opinions because he has a wide experience. From his experience, what he can inform the public, what he can, say, crystallize his views. I think that is very, very important because of the experience that he has. Therefore, he must contribute to the public debate. But those debates must be on policy issues. They should not be a rant about a particular judgment or about a particular judge. Because the moment we do that, what we are doing is we are bringing the institution down. I think an institution is always bigger than an individual. And the institutions, say, intellectual property or its, say, goodwill, is our collective inheritance. And we should not diminish it in any manner after we have demitted office also. So, air your views, but do it in a restrained manner, in a balanced manner. It should not be done in an excessive manner, commenting on each and everything. For instance, a retired judge should never participate in a political debate, as it were, on a political issue. Because the moment he does that, he shares his views. The public perception may be that his judgments, previous judgments which he has delivered, are on the basis of his opinion, which he is now disclosing to the public. And I think that will be a big letdown for the institutional integrity, as it were. Therefore, I personally think restraint should be the key word. We have in United Kingdom, I'm told, a convention which deals with retired judges. And that also mentions, or its mantra is only about restraint. They have had some wonderful cases where a judge after retirement has canvassed the use of cannabis. And naturally that press conference was held in a pub. So it was adversely commented upon, that saying, how can a judge talk loosely like this? But there have been instances. But by and large, I think most of judges who have retired have exercised restraint and have ensured that the institutional integrity is maintained.
Guru sir, of course, giving you the most difficult topic that I think, so the Instagram lawyers and the influencer style commentary that we see on Instagram, LinkedIn, or even in Facebook for that matter. So where do you think that us as professionals should draw a line between legitimate legal education and ethical impropriety?
See, my views on this are very strong. I'm sorry to say that. According to me, a lawyer going on public screen or going on Instagram and talking about what work has been done and what order has been secured is a strict no. I think that's something which is not correct at all. According to me, a lawyer should not be engaging in such kind of self-advertisement or self-promotion. What I'm saying might sound extremely conservative and orthodox, but I think that's a very high bar which has to be set. Having said that, I am alive to the fact that, as what was pointed out by Justice Manmohan right at the beginning, there must be education of the public to know what's happening. To that extent, lawyers have a very important role to play. The question is, therefore, what should be their presence on media or on Instagram, or what kind of role they can play as influencers? As you rightly said, they are influencers in the sense that what they say acquires a lot of importance. It carries a lot of weight. So to that extent, a lawyer who has not appeared in a case can perhaps give his views on a pending matter, or for that matter, a decided case. But there again, I have a caveat. I'm saying the moment there is a call to speak about or comment on a pending matter, the mantra, the byword must be restraint. Because it is very essential to remember and recall that you have a crucial role to play in influencing public opinion. There cannot be any dispute about the fact that the more that there is a debate on a pending matter, on an ongoing case, there is inadvertent pressure being exerted. I'm not trying to say that judges are such weak-minded people that they will succumb. But the fact that there is going to be pressure is undeniable. We all know about the famous Johnny Depp case. Johnny Depp case was a case which is, as is well known, was really decided much before the trial began. Of course, there was a jury there. But even here in India, where we don't have the jury system, in fact, people may recall the Nanavati case. One of the reasons why the jury system was very critically looked at in India was because of the Nanavati case. Because of the kind of pressure which was being exerted, because once you have a jury, we have people who are not legally trained. It's not a legally trained mind. Now, there I think we need to have a word of caution for Instagram and influencer lawyers.
So just drawing strength from what you said, the professional conduct rules, Guru sir, were framed when there was no digital era or the social media, to say as such. Do you feel that these rules also should now include certain checks and balances for lawyers who are on social media now?
No doubt, it has to. There has to be improvisation and adaptation. You're right, the rules were made much earlier. But I want to remind myself of one practical aspect. The game remains the same. The institution continues to be what it is, being an adjudicator. Lawyers have that role to be part of the justice delivery system and being officers of court. Now, therefore, even while it cannot be denied that technology in that sense has outpaced the law, that there's need to be a relook at the rules. But I think everything will fall in place if people ultimately understand that the game is the same. If that is understood, we need to, then everything will fall in place. In fact, I remember last year, there was some kind of an advisory or a guideline which was issued by the Bar Council of India, specifically targeting Instagram lawyers and influencers, legal influencers. So there has to be some kind of advisory or guideline, perhaps a rule, and I dare say if we have to rely on a rule for being restrained or responsible, perhaps it's not very good at all.
Justice Manmohan, what Guru sir just said, that often when matters are still fresh and pending, there's a lot of criticism online about judicial decisions and how the judge has conducted himself or herself in a particular case. So do you feel that there is a particular manner in which a judge should manage these criticism of his judgments or observations while the case is still pending?
See, the media criticism or criticism of a judgment comes with the turf. When you agree to become a judge, you have to understand that criticism will follow you. Not everyone is going to approve of all the decisions that you take. So, I think we should take it as a consequence of transparency. If you are going to live and decide in an open court, not just an open court today, it's an online court. So you have to take the criticism as it comes. Having said that, let me tell you that it should not cross a particular line. A line is crossed when right to fair trial is prejudiced, or when, say, the judge is intimidated or threatened. That should not happen. That is like really crossing the line. Criticism is healthy. It helps in evolution of the law. If a judgment is criticized, maybe Someone in a later point of time may accept that criticism and change the law. That's how the law also grows in the process. But it should never mean that a judge is feeling threatened. And according to me, a judge is supposed to decide according to the constitution, according to the law. If he or she starts deciding matters only because to avoid trolling or to get popularity, then I think someone has misunderstood his role. So criticism must be accepted. There's no problem on that score. But no one should intimidate a judge. For instance, recently a judgment was pronounced by some High Court judges. And they told me in private that, sir, our family members are receiving threats on Instagram. Now that, I think, is crossing the line. That should never be accepted. That should be curbed with an iron hand. Whatever power has to be exercised must be done, because otherwise the judge will not feel free to decide a matter. And that should never happen.
In fact, I just wanted to add a word about what fell from Justice Manmohan. See, we have this provision in the contempt of court law where attempt at interfering with or tending to interfere with a pending matter would amount to criminal contempt. In fact, that stems from, if you recall, the larger principle of scandalizing the court in English law. Now, interestingly, English law gave that up as a ground for taking action, though we continue to have it as part of our system. The contempt law continues to have it as part of the criminal law, criminal contempt process. But what is important is to understand and decide that there is a line to be drawn. Where is it that you stop the criticism of a pending of a judge or what is sought to be heard or decided, and where is it that you say, yes, there needs a legitimate discussion on what is happening in court? It's all about drawing the line at the appropriate place.
Very well said, sir. So before I proceed to the next question.
One issue I want to highlight, and that is, say someone tries to intimidate a judge. He does it on Instagram. There is an element of anonymity involved in it.
That's true.
How do you reach that source? That is the challenge which the technology is throwing at you. And somehow we'll have to find a solution to it. Because it cannot go unnoticed, it should not go unnoticed, and it will have to be dealt with. How it is to be dealt with is something which the bar and the bench must decide.
Yeah, absolutely. In fact, the problem also comes because of one reason. The large question is, therefore, some Instagram posting, how does a judge come to know? Or for that matter, how does it reach the portals of the court? Now, I think that also throws up the larger question of social media presence of judges themselves. Because the question is, how do they come to know that something like that is happening? Are we then suggesting that judges should be living in an ivory tower? Or they don't have the normal human liberty of being part of social media? At the end of the day, being humans themselves should not have the right to interact with the public on various other issues, on general issues. So these are very difficult and profound questions, but definitely require an answer.
So before we move on to the next question, I would like to welcome Honorable Justice Surya Kant and Mrs. Vashisht, who joined our session. Welcome, sir and ma'am. Justice Manmohan, moving on to the next question. Sir, how do judges conduct themselves when they find themselves in eye of the storm in high-profile cases, where you know that there is intensive media scrutiny, you know that instant public verdicts, and more often than not, people come with these applications, when they read something in the newspaper and they say, this is how it has to be. So how do you think the court has to handle such cases, sir?
See, judicial decision-making has to remain insulated from popular opinion. In fact, as a judge, one realizes that one normally decides against the public opinion. That's the nature of the job. It is contrary to the public opinion. It is anti-majoritarian opinion that you decide, because these are the people who are coming to court, people who are not getting justice because the public perception is not in their favor. They are the people who are approaching the court. So courts have to be insulated from social media chatter, as it were. And you have to decide it in accordance with law, in accordance with the Constitution. That's the oath of office that we take. It's not that we decide, we have said that we will decide matters keeping you the public opinion or the majoritarian view of the matter. At times, we have to protect the rights of the minorities, we have to protect the rights of people who may not have public opinion on their side. Therefore, the issue that needs to be appreciated is that constitutionalism is not about majority, favoring the majority. You have to take a balanced view and take a decision in accordance with law and accordance with the Constitution. That is very important. And that, I think, is reflecting the tension between what the Romans used to call the vox populi, that's the right. Popular view, and the legal view.
That's right.
So that contradiction remains even today, but we are not going to decide it in accordance with the popularity vote. It is not going to happen. We are not going to conduct a public survey, and whosoever wins that survey is going to get a decision in its favor. Then you do not require judges. Judges are bound by the law, they are bound by the Constitution, and they have to decide in accordance with that. So therefore, one should not bother about the chatter too much and should not be concerned about the eye of the storm. You should think, how is the next generation going to read this judgment? I think that's the way to let a matter when a judge decides. How the next generation appreciate it, how will the posterity deal with this judgment, not what the current majoritarian view may be in that matter.
No, in fact, I just wanted to add to that. It's something very important. All this has become very material because of what, according to me, an expansion of the role of the court itself, where it has stepped beyond the traditional in terms of deciding private disputes between parties. It is no longer an adjudicator of only private disputes. Therefore, there is a clamor for the courts to get into social issues and political issues. What is misunderstood is, court proceedings are not a plebiscite. It's a proceeding and it's not a plebiscite. That's one. And the second thing is this. What should be understood is, every decision of the executive or what is decided by the political wing need not be opposed judicially, or that a judge deciding in a particular manner is a neutral judge only if he decides against an executive decision. I mean, these are all facets which have to be understood. It should be seen that the unique role of the judge is to determine rights, take a decision on something, and today judges have, for necessity, I must say that in fairness to what is happening in court, as a matter of necessity because of governance lag, because of problems of gaps in governance and administration, have stepped into areas which are not part of their traditional role. And that's where the debate becomes even more accentuated.
So before I open the floor for some questions, in one sentence for both of you, how should justice be seen, spoken about, and shared in digital democracy? I'll start with Guru sir, so that Justice Manmohan has the last word. So my Lord will have to have the last word, so I'll start with you.
In one word. Oh, sentence?
One sentence, sir.
I'll say one word. A neutral judge.
Yes. I think there's no second opinion on this.
So we'll open the floor for some questions. Any one of you want to ask Justice Manmohan and Guru sir something from sir?
So I just wanted to make a quick comment on something Justice Manmohan touched on, the counter narrative that needs to be given. So in social media now, generally it's accepted across platforms that the best counter narrative will be the counter narrative of trust. Now, if we just leave it to some association like Scora, it may not be possible for them to give this platform of trust. We have the Supreme Court website that's very conventionally designed. Should Supreme Court's website or its public outlet platform, whatever name we want to give it, should it now be expanded to give it a more meaningful and dynamic role where all it does is it puts out this information in a trustworthy fashion So whoever is seeing whichever narrative coming, there is a trusted source they can go back to. This, sir, in the world of social media has worked the best across many platforms. Maybe something that I wanted your comments on this. And second thing, sir, just a quick question in relation to the pressure that is being exerted on judges because of social media. We now train judges, including the High Court judges and district judges. Should we now start looking at a possible curriculum or whichever in terms of training the judges with regard to how they need to deal with the social media pressure, because many of them are fending for themselves. We don't have a formal training. We don't tell them. Someone like you, sir, comes across as very balanced. I've been following you very clearly in what you have been speaking. But maybe not many of them are able to quickly grapple with that. So should we now make it a part of something that we do where judges, when they are picked and selected or when they are recruited, there needs to be some kind of a training given by some experienced judges telling them how to deal with this pressure so that they are better equipped when they actually confront this. Thank you, sir.
See, nothing is better than training by experience. You know.
Absolutely.
You learn it on the seat.
Correct.
And that's the best experience that one gets. Having said that, I think the institution that we are working in is quite well insulated, let me tell you. I don't think that we have succumbed to any pressure. We have full independence. We are not under any pressure. Therefore, if a judge goes to the social media and starts reading comments about judgments and starts coming under pressure, then I think the fault lies with him or her, not with the institution, as it were. Number two, the institution cannot get entangled in a correspondence.
Exactly.
If our institutions, please appreciate, are overloaded. You can't imagine the work the registry does. I have been a High Court Chief Justice, and I know how much of pressure the registry works under. Recently, we had a case of suicide in Delhi. One of the registry officials did it. And I understand the pressure under which the registry is working. Virtually, it's now become a 24-hour job with online filings at 4 o'clock in the morning, 3 o'clock in the morning, getting papers in order, putting everything. So there's a lot of pressure. I don't think registry can take on this additional workload. This will have to come in from the stakeholders. The stakeholders will have to step in. Please understand, the Bar Association, the SCORA, it is consisting of trained minds. It is having people who are well conversant with law. They know how these people have to be dealt with, who are imputing motives or who are giving certain statements in a particular manner. They understand that it is a trained mind.
Correct.
Which is available. And I think if it comes from an independent source, it will not look as if the institution is trying to settle scores or trying to exert a heavy hand. You know, we should not come across as a person who's trying to exert pressure or trying to exert a heavy hand. That should not happen. Therefore, an independent body like SCORA or Supreme Court Bar Association, if they take the lead in that, I think that will be crucial and that will be helpful.
In fact, just to, I'm so sorry. In fact, just to add to what Justice Manmohan mentioned, I think what has to be understood is the court as an institution should not be seen as one side which is trying to justify itself. By making an attempt to come up with anything like that, you are really ending up being part of a certain muddle. You see, yesterday there was an order passed by the Supreme Court that there must be some kind of a template for media briefing by the investigating agencies. Now there we are looking at a victim or a person who is accused versus an establishment being the investigating agency, which is supposed to be not doing its job. But when you are talking about the court as institution for a decision to have been taken, surely the court cannot put up on the website why a certain decision was taken in a certain manner. All that the court can say as part of its website is a decision has been taken. So I don't think it's advisable to look at an engagement directly by the court as an institution on social media.
But one thing I want to emphasize, and that is that if the public wants to see a T20 match, you cannot insist today that you will play only the test cricket because that is the real cricket. So I think we all have to adapt.
Yeah.
the bar, the bench, everyone will have to adapt to the new scenario. And I think therefore it calls for some introspection. But maybe the suggestion can be considered, but according to us, we have a feeling that it has a downside to it, because that will entangle the registry with the public at large, which should not happen. And allow the public to arrive at a conclusion whether the judgment is right or wrong, whatever.
Well, Manmohan, I must congratulate the Skora for having taken an explosive subject on the fireside chat.
You're right, absolutely. In fact, I told them I don't want to get burnt.
It's because so explosive that I even go straight coming from, I thought I'll just stay apart for a while and go. 2-3 reasons, so you people are also there. Guru, I would say, since Sora is also the listening side over here, it's not the court actually step into. The court is actually dragged.
I agree.
So that part, the media, the public, and the lawyers should be very circumspect in dragging the court into unnecessary areas, number one. Number two, equally the court should be very vigilant in not stepping into popular areas, policy areas, where, and particularly to me, Supreme Court, there are 24 high courts in the country. It's not as if that everything should be taken up by the Supreme Court. Only Supreme Court can take up all these 32, all these fundamental rights violation or big issues. I think it's time for the capital situated the Supreme Court also to say that there are 24 high courts in the country. It's not that everything should come under 32 here. And third, we have been saying about neutral judge, popular judge, what do you call, there are so many adjectives to the accused judge, so many adjectives. I must say a judge with a constitutional conscience. If the judge is in a position to say, whenever he decides an issue, what the Constitution says about it, he should have only that lens. Because he is appointed, he takes oath under Schedule 3 to uphold the Constitution and the laws. Not uphold one's ideology, once uphold one's own philosophy, once uphold one's own religious views. All of us have that. The moment we become a judge, we take an oath and we discharge that duty. Our duty is only to uphold the Constitution. So we can only say, we should only say, and we need to say what the Constitution speaks about this. Thank you.
I must say at the outset, a very warm welcome to the ever-smiling and neutral and constitutionally conscious Judge, Justice Kurian Joseph. We are very happy to be amidst his mess. We are missing him in court, but we are happy that he's here as part of the discussion. And the catchphrase that we lawyers use in court, I cannot put it better than your lordship, on all the 3 points. It's right that in many instances, the court is being dragged into instances and situations which are unseemly. I cannot agree more. The second thing is, the court to that extent must also be guarded. Because we are in an era where, according to me, it's no longer public vigil, but unfortunately vigilantism. In that era, I think the court has to be more careful, ensuring that it doesn't inadvertently slip into that area of controversy in that sense. And thirdly, of course, absolutely, the position of a judge is such that he swears by Constitution and the ideal and the values of the Constitution. Thank you for highlighting that, sir. Thank you.
Hi, sir. Drawing a leaf from Justice Joseph, and I will therefore not drag Justice Manmohan to my question. So therefore, I'm directing it to you, sir. We have seen in very recent times a trend in social media specifically, with lawyers coming out with what we call legal advice in REM. Just to give you an instance, there are many reels that are circulating, say, how do husbands get out of the rigors of maintenance, or how to escape if a dowry case is filed against you. So what do you think are the solutions to this growing menace? Because they are targeting a specific audience as a clickbait, as we like to call it in the social media lingo. So, sir, what are your thoughts on this?
See, the jargon and the lingo that you have used, unfortunately, is with reference to advice for husbands with regard to their wives. Now, unfortunately, for me to respond to this in the presence of my spouse is not something very pleasant at all. But nevertheless, the point is well taken. This is something I think we discussed a little while ago. See, the tendency appears to be able to have, to be able to reach a ready audience. Social media has that huge potential. Its reach is stupendous. It's outstanding. And I must say for good reasons. The transparency it brings in is something which is outstanding. What happens is when there is a misuse. That's where the problem really comes, and I think that's a matter of self-restraint. We, of course, can bring in rules and say that something like what you're saying is, which is being done is a strict no by itself, bar it, prohibit it by all means. But you must have something beyond that. As part of an educated profession, we serve a very important role in the scheme of things in the society. There must be self-restraint. I think that's really the key.
Thank you so much, sir. So before we close, we would like to felicitate both of you for being here and, of course, agreeing to do the session for us, sir. May I call Ms. Mittu Jain, advocate on record, to kindly felicitate Honorable Justice Manmohan with the bouquet with us today. And may I request Mr. Sanjeev Kaushik, advocate, to present a memento to Justice Manmohan for support and faith in us and for agreeing to Fireside with us, sir. May I request Mr. Nipun Saxena to kindly present Mr. Krishna Kumar with a bouquet. May I request Mr. Kunal Chatterjee to present a memento to Mr. Guru Krishna Kumar for his candid responses. Thank you so much, everyone, for being with us. It might be the breakfast, but I'm glad all of you could join us today. Thank you so much, sir. Thank you.
Thank you, everyone.
I think we owe a special thanks to Astha
yes,
for conducting this program and for working very hard on this.
Yeah. Thank you, everybody. Yeah. Thank you. Thanks.
Super job.
Lovely job, Asta.
I was telling sir,
it's not natural. The first time topics discussed like this.
Asta, thanks. Lovely.
Thank you so much, sir. Thank you. Sir, we bring this mantra to you.